Mentioning list.
Mentioning.
My lord, I may be excused, my lord, for mentioning. Item number 9, my lord. My clients already retired from service, my lord. They want to go back to mainland.
All
For
right.
this purpose, this case purpose, they are staying back.
Yes.
So I pray for this very short matter, my lord. This may be taken up before rising.
Yes, we are here.
My lord.
No reason to think that we are rising immediately.
My lord.
Item number 1, MAT 14 of 2023.
The appeal has been dismissed. The reasons will be put up in the server. Please check up.
I am highly obliged.
You please take back all the judgments that you handed
My
me
lord.
yesterday.
Item number 2, WPCT 20 of 2023.
The writ petition has been dismissed.
Obliged.
Item number 3, WPCT 37 of 2023.
The order of dismissal has been set aside and the administration has been directed to revisit the proceeding from the stage of forwarding the inquiry report to the employee. It is made clear that the court does not find any lapse on the part of the inquiry officer in preparing his report, and as such, the same is not interfered. There is no requirement or occasion of granting opportunity of further hearing before the inquiry officer. It will be open for the employee to raise all issues apropos the inquiry report before the disciplinary proceeding. And since the matter is pending from 2015, the authority has been directed to grant opportunity of hearing to the employee and conclude the proceeding at the earliest, but positively within 45 days from the date of communication. The order of the tribunal quashing the inquiry report is accordingly set aside.
Item number 4, MAT 4 of 2023.
Lordship, I appeal for the appellants in this matter. Now, ample opportunity was given to the respondents to file the affidavit in opposition. Till 22nd of this month, they were given opportunity to file AO. Till date, it has not.
No, my lords, only once it was given, my lords. Otherwise, this matter can be heard, my lords. It's unnecessary because they have.
Let it proceed in the next circuit for hearing, admission hearing.
You will not file any opposition?
No, I'm requesting for extension, my lords. One of, they are, it is really a benefit.
What passed earlier is extended till the next circuit.
One opportunity, my lords, is granted. This is a response to leave to appeal, my lords. I don't know why they are.
Intimity is there, but the time to file the opposition has expired. 22nd August is over. Please come. On the request of the learned advocate representing the. Who will be you? Who will be representing? Who are you representing?
As I am representing the administration, but also the petitioner in the appellant in item number 5 had also requested to, but they are not representing.
Yes, Lord.
Whether they are also requesting for extension.
Yes, Lord.
What? Yes.
Actually, my senior is not here, so let it be pushed to the next circuit.
No, but then he is praying for hearing of the matter, and how can it be posted mechanically?
Then let it be in short password, my lord. My senior is coming, my lord.
Short password. Request of the learned advocate representing the administration, and who are you representing?
Appellant in item 3. In item
Mat 3.
Appellant in item 5.
Mat 3, I am
Mat 3
representing
and
the administrator.
And the appellant in Mat 3/2023. Time to file the opposition is peremptorily extended by a fortnight.
My lord.
Reply, if any, by a week thereafter. list in the next available circuit. The interim order that is subsisting in the matter,
Item 4, my lords, there is no interim order in the first matter. Interim
Mat
order-
3,
Mat
Yes,
three.
no, it is
the
already
interim
extended.
order. So we are not extending it any further?
No, it is already, no, my lord,
Not
my
yet.
lord.
Interim order subsisting in Mat 3 2023 is extended till 22nd September 2023 or until further order, whichever is earlier.
Deep privilege.
Oblige, my lord.
Affidavit आया क्या? नहीं, कोर्ट में affidavit test है.
Item number 6.
My lord, I am appearing for the
WPCT 25 of 2023.
petitioner, my lord. On the other day, my lord has directed them and even asked me to ascertain that period, during that period, what is the amount which is payable to my client, my lord, that 130 days.
That affidavit was filed, my lords, in the registry in the morning, my lords. It hasn't come. I can give my lords my.
Yes,
My lord, they have informed some 50 or some thousand for the set period.
No, my lords will see. This is the. It has been
what
filed.
is the amount figure?
My lord,
No,
page,
my lords, in this affidavit, my lords, we have said that the total from 2003 till date, the total figure is 2,47,000. But
Leave allowance?
no, that for that duration of 3 months, in the
Yes.
affidavit, we have said that we need some time. But today morning, I have informally, I have been given instructions that during that period, it is 41,230.
my lord, kindly come to their first document in the affidavit, my lord. Affidavit. नहीं है.
Order number 177,
My lord, this is the period, my lord. Order number 1.
period on leave,
This is the
80 days. Yeah, এটা ফেরত দিয়ে দিন।
Got it.
80 days. No, 80 days will not be there.
No, my lord, total 134 days, my lord. From 10th
Yes.
September 2020 to 21st January 2021. my lord.
Right,
Yes.
and they are deducting for the period of 3 months only,
No, my lord, both are deduction, my lord.
both,
Because earned leave, it is from my leave encashment.
yes.
And this half pay leave means, my lord, this 54 days means 17 days of my, that period is taken. So total 97 days of my earned leave, which I am entitled, that has been taken by them. And at the same time, the salary for the said period was not given to me. The amount which was lying in my leave encashment, that was taken to adjust it, and the salary for the period was not given to me.
My lords, the written oral instruction which I've got in writing now, total salary without treating leave is 4,18,724 and paid after treating leave is 3,77,493. So the difference is 41,231 for the duration between September 2020 and January 2021. This is the tabulation.
My lord, so far as this amount is concerned, my lord, I cannot, because if the pay and account office can say. My lord,
This is what their figure says.
but my lord, ultimately the authority is the pay and account office, my lord. So whatever due is there, my lord, I may get. I am not asking anything else, my lord. And my client, my lord, she is not well, therefore unable to come, my lord. She even did not, I have talked over phone, my lord. She again went for
No, she
treatment.
was not required to come
My
here.
lord, even she did not able to come to my chamber because she had undergone hip operation and all.
So right now, the claim is only 41,230.
They are saying, my lord, amount, my lord, there may be variation. I say, my lord, whatever, I don't ask anything
You
more
don't
than.
want the figures to be mentioned?
Let the pay and account office, whatever the pay and account office gives, we will accept.
The lady is in a very wretched condition. What can be done?
Whatever your lordship deems fit, my lord. Or if they want to file an objection to
No,
the,
I don't want to file any objection.
Because they cannot object,
Yes.
my lord.
because these are on records. Where was the offending part in the judgment of the trial?
Yes, my lord.
After present direction is issued to reconsider the case of the petitioner as per law. Direction has been given to reconsider your case.
Reconsideration without going into the, my lord, the order by which they have appointed is, they have set aside the transfer order is at page number 63. Up to that stage, my lord, the order was absolutely correct, my lord, 63. I have been aggrieved by the subsequent order at page 65.
65.
The relevant would be page 66, last 3 line, my lord.
Yes, the intervening period till her resumption on duty shall be regularized by granting admissible leave. And did the tribunal make any observation with regard to this period?
No, my lord. Tribunal did not enter into the merit at all, my lord. Kindly see the order. Kindly come to page 111, paragraph number 8.
Paragraph?
Paragraph number 8, my lord, page 111, inner page 7.
Yes, but what about the observation with regard to this portion? Admissible leave, resumption on duty, regularized on admissible leave, nothing.
No,
Paragraph 8 is only consideration.
tribunal without entering into the merit, rather wrongly considering the merit. If my lord sees 112, the tribunal said to consider my representation, which was already rejected by an order by the authority. Page 112, my lord will find representation. That representation was already rejected by the authority by an order.
What's the
By
question?
an order dated page
28 January 2021. That is the impugned order. Then 2021.
My lords, the question is whether she had come to, like, she had reported for duty or not, my lords. That is the question, which is why the tribunal has not interfered into the.
Now she has retired from service.
my lord,
Yes.
April 2021.
In April 2021. No use going back to that all over again. 30th of April. Please come.
Only thing, my lords, is that the tribunal is not, does not have the authority as your lordships have. So, my lords, to that extent, my lords, the order of the tribunal is not wrong also, my lords. What I'm saying.
The petitioner has retired from service on attaining her normal age of superannuation on 30th April 2021. She is aggrieved by the order of the no, not she is being aggrieved by the order of the director, Andaman and Nicobar Administration, Directorate of Health Services, dated 28th January 2021, whereby the intervening period with effect from 10th September 2021 till her resumption on duty has been directed to be regularized by granting admissible leave. She approached the tribunal by filing original application. Stop. The learned tribunal disposed of the matter by passing direction upon the authority to reconsider the case of the petitioner as per law. Stop. Paragraph. Upon hearing the parties in details and upon perusal of the materials on record, it appears that the period in dispute is from 10th September 2020 till her resumption on 21st January 2021. Is the date correct?
Resumption is on 22nd January. my lord.
22nd January 2021. Stop. The leave encashment for the said period which the petitioner would have received has been directed to be adjusted on account of her absence. Stop. On account of her alleged absence. Paragraph. Learned advocate representing the petitioner categorically submits that the petitioner regularly attended duty during the said period, but the administration deliberately did not permit her to sign the attendance register as the transfer order was passed in her favor. Stop. Next. Paragraph. It appears that the transfer order was thereafter revoked and the petitioner was directed to report to duty on and from 22nd January 2021, which the petitioner readily accepted. Stop. Next. Paragraph. Learned advocate representing the petitioner submits that the petitioner is suffering from various old age ailments and it will be highly prejudicial if the old age ailments and she requires finances to continue her medical treatment. Stop. If the leave encashment is adjusted, then the petitioner will be highly prejudiced. Stop. Next paragraph. It appears that it appears from the figures which has been placed before this court by the learned advocate representing the administration that a paltry sum of rupees 41,231 will be the amount for the period during which the petitioner has been alleged to remain absent from duty. Stop. Next. As there is no definite finding that the petitioner did not report to duty, but the petitioner contends that she reported to duty, but was not permitted to sign the attendance register. Accordingly, the court thinks it fit to direct the administration not to adjust the leave encashment during the period the petitioner is alleged to remain out of service. Now, petitioner has during the period the petitioner was treated as absent. Stop. The balance payment of the petitioner, not balance, the arrears of the petitioner, the arrears of terminal benefit of the petitioner be released by the administration at the earliest. The writ petition stands disposed of.
My lords, where your lordships have said, I recorded my submission, my lords, my request may add on
On
instruction.
instructions. The calculation handed over by the learned advocate representing the administration. Be retained with the records.
My lord, any time frame may be given, my lord, any time frame, so that
What are the due of your petitioner right now?
Everything-
Pension,
No, no,
provident
everything
fund?
no, everything has to be fixed in terms of that period will be calculated and accordingly, everything has
Did
to
you
be
get
refixed.
anything in your hand?
Yes, yes.
Yes, provisional pension we are getting.
Provisional
Pension, we are
pension.
provisional
Pension.
pension or provisional
No,
pension.
no,
we are getting.
pension is.
But my lord, it has to be calculated by taking that period, my lord. So whatever may be done within a time frame.
The terminal benefits be disbursed positively within a period of 8 weeks from the date of communication of this order.
Fine.
Acha, one more line, affidavit, is it required to be recorded that the affidavit is filed or is it recorded in the
No, no, my lord.
administration?
Let it be recorded, my lord, the affidavit is.
Affidavit on behalf of the respondent numbers 3, 4, 5 and 6 filed in court, be retained with the records.
Obliged.
Item number 7.
My lord,
in
in this case, my lords, on the last occasion, my lords had put it to the administration that whether they can give something in writing to say that the benefit under that August circular of 1/30 will be conferred on my learned seniors clients. So, my lords, I have received it. Received it.
But your lordship, there is some change, your lordship. In 2000, your lordship, a writ petition was filed by the employees of the same department. And there, your lordship, it was ordered that from initial date of appointment, it should be given, and they have been given. So one set of employee, you are giving it from the initial date of appointment, and another set of employee you won't give. There, what I have cited on that particular date, though there was an order, but they have not followed and they have given it from the subsequent dates. But in that case, they have given it from the initial date of appointment. I have the documents to show.
Then it has to be heard, my lord.
Yes, it is to be heard. This requires to be heard. Will you submit anything today? Any file?
I have got this written instruction, my lord.
Then keep it with you, file it on the next occasion.
My lord.
The matter requires to be heard. Stop. Let the same appear in the next circuit.
Item number 8. WPC 36 of 23.
Shatrughan, I have, in compliance with the orders so passed, I'm filing the paper book. Being the last day, this has to be taken up in the next circuit. Let this be.
Has it been served?
Yes, now it has been taken on record.
Paper books are taken on record. List the matter in the next circuit for hearing,
Blair.
subject to the convenience of the court.
Item number 9.
Lord, I am for the
30th of 2023.
This matter, my lords, was mentioned by Mr. Prashant in the morning, my lords. I am, my lords, if it pleases your lordship, I'll argue, my lords, for hearing.
Why?
what
They
matter.
wanted, he want.
My
he had
clients
mentioned
already
this fact.
retired, my lord.
Yes?
They are
My
getting
clients
pension.
already retired.
Hmm.
They want to go back their native place because of this case.
Who is stopping them?
Benefits were not
They are
given.
getting pension, it says that.
Gratuity was upheld,
Gratuity was upheld, gratuity not paid.
not paid, my lord.
Why is gratuity being held?
No, my lords, everything is other than, no, the higher rate has to be paid if it is regularization is to be taken from the date of appointment.
It's not a matter of.
It is not that, my lord. It is not a question of regularization. We were initially appointed on ad hoc basis. After some period, under the UPSC, we were regularized. The ad hoc period was counted for the seniority.
Not
Sir,
from the
sir.
other, not from the initial date of joining.
Yes,
You want that
all
period.
benefit were given.
Already
CAT
given.
CAT allowed our application. They filed the
My appeal, my
against
lords,
that.
if they-
Very, very short matter.
Your lordship,
I don't think it is a short matter, but if
is
I'm
short matter.
ready, my lords, I'm not.
All this matter was appeared by the Honorable Apex Court.
That is why it's an
It is
appeal.
all right. It is all right, but then this is to be hard
My lord,
until the last day. It's absolutely not possible.
very, very short matter.
We were here till 10 o'clock yesterday
I
night.
know that, my lord.
Now you don't expect us to wait today also.
My lord, 10 minutes it will take, my lord.
No, he says it won't be completed.
No, point is very short, my lord. Only one.
Your point
Every
is
matter
short.
point is short.
My lord, they want to, their intention is to drag the matter.
I
No,
understand.
no, there's.
My lord, we are in difficulty, my lord. Kindly appreciate, my lord. Lordship, kindly remember this matter I used to mention every now and then.
But then your client has got something at.
My lord, kindly see, my lord. This
How much is the difference that you are,
Run lakhs, my lord.
huge difference.
Lakhs.
huge difference?
Yes.
They are drawing pension over a lakh, my lord.
Maybe
Actually, they
you are not giving any charity.
1 minute.
It is our service.
No, no. but
When
not
were
like-
you appointed? The later date, when is the date from which the benefits have been calculated?
From
which
the date of,
Date, give me the
Regular.
date. Give me the months.
that the date, my lord, I'm giving.
In fact, if the administration is correct, then we'll be
Fourth-
entitled to recover from them.
4th May 1998.
4th May 1998, it is from this date that you are getting. And when was your initial appointment?
Initial appointment, my lord, 1 second, my lord. 14 June 1988.
More than 10 years.
Yes, my lord.
Actually, your lordship.
No, my lords,
will not be-
may I just submit.
Very quick matter, not big.
No, my lords, it is, my lords, may I just explain, my lords? This is slightly different from what has been just now submitted.
No, 10 years. I
No,
think
it is not 10 years actually, my lords.
How
They-
much?
It is not like that, my lords. What is the question? It is not a case of arrears here. They have been paid as per the regularization order. Everything was treated from the date of initial appointment.
Yes, I
But
followed.
after that, when UPSC, when there was a audit on an audit query, it was decided that this should be refixed. So here the fight is for determination. In the case, one of them has retired. So for the retired person, the case is that naturally, if it is taken from the date of appointment, higher pension that person will be entitled to. And in the other case, my lords, of course, for the continuing duration also, because the administration has been recovering, as I have to be frank and prepared to tell the court, that after this refixation, administration has been recovering. So that, of course, if they succeed, then they will be entitled to refund of that amount. Well, that is the issue over here. The issue is whether.
Have you recovered anything from the petitioners?
No, not in the
From the
second case,
petitioners.
not in the second case. Because Vijay Kumar has retired. So one person has retired. So far as the person who has retired is.
9 and 10 are similar matters.
Yes, one is in service, one is retired.
All right.
So the retired person, there is no recovery because only lesser pension is being paid. But the person who is in service, there, because those benefits have already been given, there, that is being deducted. Now that technically, well, that is an issue, but the point is that the, what is to be decided is whether this benefit is to be given from the date of initial appointment or the date of regular.
This is the only point, my lord.
It is
This was already settled, lordship.
It is to be hard.
My lord,
Please
kindly
excuse
fact-
us. It will not be possible.
My lord, only one page I will show, only one page.
I have to.
He will show 10 pages.
No, that it was already settled law, my lord.
No,
He said,
nothing is settled in the honorable court.
It was adjudicated up to Honorable Apex Court, my lord.
next circuit. And prior to that, let the matter is required to be heard. Let it be placed before the next circuit. So we are over. Next set of 10 is same order.
My lord, just one, I apologize, my lord, to mention, Mr. Kumar is also in court, my lord. The first matter which your lordships had pronounced where my lords have
Yes.
dismissed the appeal. My lords, that matter is listed before, in the contempt matter is listed today before the learned single judge. My lords, we'll have to wait for the order, my lords, whether there is any change.
I will submit, nothing to worry, I will
The order will be put up in the
When?
server immediately.
I will take care of it, today nothing will happen.
At what time? It will be done on,
2 PM.
we see.
2 PM.
By that time, the order will be.
Yeah,
It will be done.
if it comes a week later, I'm not saying.
No, that I know you'll be happy. That is the reason we put it in the server immediately.
Item number on WPA 4 of 2019, 2009.
My lord, in this matter, I crave leave to make submission, though I don't have my Vokalatnam. I received a
For whom are you appearing?
petition.
All right,
This morning, I received call from the petitioner that he intends to engage some other advocate. Since Mr. Binu Kumar, my eldest brother, was the advocate earlier. So he has asked me to just pray for an adjournment in next session. I don't have any idea, my lord. I'll be very candid before my lord, since I don't have any idea regarding the petition.
My submission was that this has now become infructuous because of
Yes.
similar orders passed in.
and this is matter is pending from 2009. This is what you are thinking of if it could be disposed of.
My lord, I don't have any idea, to be very candid, but as I received a phone call, I'm just making my humble submission, my lord, because I don't hold my Vakalatnam out
The
there.
request has been made by so and so learned advocate on behalf of the petitioner to place the matter before the next circuit. So, on such prayer, let the matter be placed before the next circuit.
I'm grateful, my lord. Sorry for the inconvenience, my lord.
No, it couldn't be helped.
Item number 2, WPA 848.
My lord, I am appearing for the petitioner in this matter. My lord, I am appearing for the petitioner in this matter, my lord. My lord, admittedly, my lord, my lord, I am appearing for the petitioner. My lord, here, my main challenge of the matter is, my lord, the order impugned, which is at page number 80, your lordship, which is passed by the controlling authority. Petitioner are by nature a mini deposit collector. My lord, I admit that the Supreme Court has clarified that they come under the purview of workers, my lord, and that's why the appropriate forum would be the appellate authority. My lord, the reason for coming before this honorable court is that there is a delay on the part of the bank in filing, my lord, the appeal. They couldn't file the appeal on time. My lord, if my lord may come to section 7, subsection 7 of the Payment of Gratuity Act, my lord will see that the highest days for condoning the delay, the power which the appellate authority has is of 120 days. And my lord, the bank has made a delay for filing this appeal, my lord, of more than 300 days. That is why, my lord, we have approached this honorable court, my lord. My lord, we are ready to deposit the money with the registrar, and if your lordship so please, my lord, then we will proceed with the merits of the matter.
But then why will the delay be condoned in the very first place? Did you serve copy?
My lord, for
Respondents?
my lord, I have served the copy, my lord.
Appearing through SLSM road, State
Yes.
Legal Services Authority.
Which respondent?
Respondent number 2, the person who was the claimant was approached to the
S. Sundara.
Sundarajan. Not my submission is that not this application is not maintainable.
Where will you file your
Without-
application? Learned
My
advocate.
lord,
The respondent number 2 seeks time to file opposition in the matter. Stop. It has been submitted by the claimant that the writ petition is not maintainable. Stop. Start the paragraph by mentioning learned advocate representing the petitioner prays for condoning the delay in approaching the competent forum.
my
And
lord, we have not approached, my lord. We have not approached because we have not preferred the appeal. We have straight away come before this honorable court. We couldn't file the appeal because there was a delay, and that is why we have approached the honorable court by way of this writ petition.
what did I mention? In approaching the competent forum under the Payment of Gratuity Act 1972. Let affidavit in opposition be filed. What about the respondent number 1?
My lord, we have served.
I will let affidavit in opposition be filed by 3 weeks.
2 weeks, my lord, because it is,
2 will be all right?
yes, ma'am. It is already, yes, prepared it, my lord.
Very well, 2 weeks. Reply if any by a week thereafter, list before the available circuit.
Lord, the point of maintainability may be
The
kept.
point of maintainability is kept open,
Yes.
should be decided at the time of hearing of the writ petition.
Obliged.
I have
Sure.
your submission that you are alleging that the petition is not maintainable.
Obliged.
Next one is also same.
No, my lord. Grateful to your lordship.
Item number 3 and 4,
Service is not actually, so that is go to the next section.
Both? Very well. Learned advocate for the petitioner submits that service is not complete. Stop. Let the matter be placed in the next circuit. Stop service in the meantime.
May be recorded by laws for the electoral officer. It's called the
Learned advocate such and such represents the respondent number 5.
In fact, my lord, yes, sir, for the time being, my lord, let it be for 5.
And 5 in both the matters. Respondent number 5 in the second matter also.
Yes.
Very well.
Item number 5, CPN 18 of 2022.
Yes,
Order passed by the lordship.
yes.
But I think there is a mistake because my lord, there is no case of PS Sahu. I think there is a mistake in the
First title.
first side because there is one case of PS Sahu. But I don't know which order content is. PS Sahu petition, my lord. Or is there a mistake in the cause list? ওখানে সাহু না সাহু সাহু আচ্ছা then there is a mistake in the cause list.
Yeah. It's a B হবে এটা H হয়ে গেছে. Who is the learned advocate? Please check out. On record that sheet. নীলাঞ্জন অধিকারী তো হাইকোর্টের উকিল. Link. Did he seek for any link? But then Mr. Chakraborty, possibly you'll appear for the contemner in this case?
Yes.
Has the order been complied? Any idea?
My lord, that short instructions, my lord, there the operator direction was to complete the discipline.
Yes.
Within the time frame.
Why don't you conclude it?
Yes, my lord, that it was the inquiry was directed, however, it is at the final stage, my lord, I think it will be done. my lord.
I'll record your submission.
But, I know that it was record, I know that I'm seeking some time. my lord.
None represents the petitioner at the time of call. Stop. Learned advocate representing the alleged contemner seeks extension of time for complying the direction passed by the court. Stop. Next. On such prayer, let the order passed by the court be complied with. How soon? 4 weeks?
The only thing is, my lord, the contempt petition is the first date, first hearing.
So what? How many dates can it go?
Contempt is not served. actually.
You didn't receive a copy also?
Without notice, contempt is usually not served.
Yes.
It's the first time. I don't know, is there?
Very-
I couldn't find, there was no order on the website. I think it's coming for the first time.
No order is there. No order is there.
But then
In
I
that
get
case.
that benefit. Right.
Let copy of the contempt application be served.
My lord, in item number 5, my lord, I am on behalf of the petitioner, my lord.
Yes.
My lord, lordship passes the order to serve a copy to the alleged contemner, my lord.
Please serve copy.
Yes, my lord. I'll serve copy, my lord.
Here he can accept copy.
Yes, my lord.
Serve the contemptor. Let a copy of the contempt application be served upon the alleged contemptor. Stop. Let affidavit of compliance be filed on the adjourned date. List on 20th of November, 20. Yes,
Supplementary cause list, item number on. Detailed 13 of
I have been
2023.
told some typographical mistake in the repetition number.
it appears that the number of the writ petition
Writ
was longly recorded in the order dated 21st August 2023. Stuff. The correct number will be WPA 944/2022. Stuff. The department is directed to make the immediately make necessary correction. Stuff. Rest of the order remains unaltered.
Okay.
ঠিক আছে?
Okay.